Hello and welcome. Welcome to KCA's 2023 Employer Educational Series. This series is titled The Impact of Drug Testing and Drug Use in the Era of Expanding Medical and Recreational Marijuana. Through the KCA board and the education committee, we've crafted what we think is a good 5-part series. Today's the kickoff. And we have Joshua Horn from Fox Rothschild to kick it off. And then following that, we have a session in May titled Evolving Risk in Construction Associated with Increasing Drug Use. In August, we have the pros and cons of drug testing in construction. And we will be discussing the medical marijuana card at that one. So that will probably have a lot of questions there. The third session to be held in October, it's the current and potential future impact of legislation on drug testing and drug use in construction. And then we're going to bring it home in December with our good friends at the National Safety Council. They created an awesome impairment worker detection training series or a session. So they're going to talk about worker impairment best practices and how to know when someone seems to be impaired. But yeah, without further ado, I'm sure you don't want me to keep talking. I'm sure you want to hear Josh and hear about his great program that he has here, his great presentation. So please welcome Joshua Horn from Fox Rothschild. Thank you.
Thanks, John. I appreciate it. Welcome, everyone. So for about the next, 40 minutes plus or minus or so, we'll go through the presentation. Unfortunately, I do have a hard stop at 3, but I think we'll have plenty of time. If anyone has questions during the course of the presentation, please, don't hesitate. I mean, I'd rather have questions and answers and not get through the PowerPoint as opposed to just, walking through the PowerPoint, because I can certainly, share the PowerPoint with you if you'd like. And so let me just back up here. So by way of introduction, my name is Joshua Horn. I'm a partner in Philadelphia at the law firm of Fox Rothschild. I've been here for 27 years. We have 29 offices around the country. We actually have a pretty robust construction law practice as well. But my space, I'm co-chair of the Cannabis Law Practice Group here at Fox, and have represent medical marijuana and adult use marijuana companies around the country, and everything from soup to nuts that you would do for any other company. And I also happen to speak quite frequently on issues about marijuana in the workplace, in particular in the context of Pennsylvania's Medical Marijuana Act and kind of the implications that it has for you folks, particularly in the construction industry. I've testified before City Council in Philadelphia. I've done this presentation to National Manufacturers Association in St. Louis, and I've done it for Pennsylvania Realtors Association. So it's it's a subject I know quite well, and there's a lot of issues and a lot of thorny problems that you guys unfortunately have to deal with, because the law isn't exactly the modicum of clarity, and there's a lot of risk out there, to such a degree that some companies that used to have mandatory drug testing policies just don't do it anymore, because basically anyone could be taking cannabis in some form and would test hot, irrespective of whether they're under the influence at the time or not. And so there's companies, they're just I can't be bothered with it anymore, and they'll just take their risk, if you will. So we'll talk about those things. And like I said, if anyone has questions, please feel free to chime in, and I'm happy to answer them. So what are we going to talk about? So first, I want to give you really an overview of where we are, on a national level and what it means, and then really use the Pennsylvania Medical Marijuana Program as the case study, and wrap it up with some practical tips that you may find of interest, for your businesses. And so we lived under this environment for many years of reefer madness. And so, this was the type of thing you would see in a newspaper at any given point in time after 1937, when the Marijuana Tax Act was put into place, which was in essence, the first effort to regulate and ultimately ban marijuana as a controlled substance in the United States. And prior to 1937, cannabis was widely used for medical purposes throughout the country, and doctors would prescribe it. And so, but in 1937, there was a fellow in the federal government who was decidedly anti-marijuana and anti the groups who were perceived to be using marijuana. And so, he pushed for the the Cannabis Marijuana Tax Act, and that's we got to all the reefer madness that came out after that. And so we still deal with that to a degree, but not as much as not as much certainly as we used to. So moving forward, so here's what you need to understand. So you have two sets of laws that we're dealing with. You have federal law, and federal law typically preempts state law. And what does preemption mean? Preemption means that if you compare federal law against state law, federal law takes priority over state law. But that's not always the case. And so, but what we have in the cannabis context, we have what's called the Controlled Substances Act. The Controlled Substances Act was a law that was passed in 1971, signed into law by President Nixon, and listed marijuana as a Schedule I controlled substance, which on that list you also have LSD, methamphetamine, MD, and I think MDMA, cocaine, and so it was really grouped, with all these, heroin, all these other drugs, which basically the law, in essence, says is that these are substances that have a high likelihood of abuse, and are substances that don't have a medical application and can't otherwise be promoted through a medical application. And the interesting thing, at least as to marijuana at the time, there were studies that the president had at his disposal that basically contradicted all three of those conclusions. But he was preoccupied with passing the Controlled Substances Act and really going after the marijuana business because, among other things, there was along racial lines, and it was along he perceived certain races as his enemy, and he perceived hippies as his enemy. So he really pushed to have this law put into place. And so what does it mean? So on a federal level, it means that it's illegal to possess, manufacture, distribute, or dispense cannabis, or just conspire to do so, meaning working with somebody else to do those very things. Now, over the years, there's been a lot of pieces of legislation ostensibly to either deschedule, reschedule, or make marijuana legal in total. Hundreds of laws have been proposed, none of which have really gotten all that much traction. The only laws that really get traction, at least at this point, are those more in the financial services industry, but nothing's passed yet. So we still have this, what I call federal state dichotomy, where you have the federal government, which says it's illegal, and then you have state governments that are saying that it's legal to be within the state. We also have something that's called the Farm Bill of 2018. So you have to remember there's cannabis sativa L plant, and there's two different types of cannabis sativa L plants. There's the traditional cannabis. That's the stuff that your friends were growing in their closet in the dorm in college with a black light, and you'd smoke and you get high. That's the product that has high THC. Then there's this other cannabis sativa L plant, and that's hemp. And you can smoke hemp until the cows come home, and you won't get high on it. You'll probably get sick, but you won't get high on it. And hemp, you may or may not know, 150 years ago, hemp was the biggest cash crop in the Commonwealth of Pennsylvania. And hemp can be used for clothing. It can be used for rope and industrial materials. People use it for concrete now because of its strength. But it also has a chemical in it called CBD, cannabidiol, which has, some people believe, has some curative health powers, anti-inflammatories in particular. And so what the Farm Bill did, the Farm Bill removed hemp from Schedule I of Controlled Substances Act. So what does that mean? That means that hemp, as long as it's grown in conformity with the Farm Bill and what it provides, is federally legal. So you'll see there are hemp farms in Pennsylvania now. And so it is federally legal to grow and sell hemp. And that is subject to the oversight of the U.S. Department of Agriculture. And then it basically, if you will, subcontracts the regulatory obligation over the growth of hemp to the state departments of agriculture, who can develop their own programs, require permits, and that's what the Pennsylvania Department of Agriculture has done. The USDA approved their plan a couple of years ago, and so you can get a hemp permit once a year, and you can grow hemp and you can sell it. And okay, so what's the other thing in hemp? The other thing in hemp is the CBD, which is the thing that people claim to have curative health powers. And so CBD, which is a derivative from hemp, that is subject to the oversight of the Food and Drug Administration. And the Food and Drug Administration has taken the position that CBD from hemp is a drug because the Food and Drug Administration approved a drug called Epidiolex, which is a prescription drug that's used for the treatment of two very rare forms of childhood epilepsy. And so, so the FDA takes the position that it's against the Food and Drug and Cosmetic Act to put CBD in food or beverages or sell it as a drug without the FDA's approval. Now, I'm sure lots of you are scratching your head by that statement because you probably go into any store, convenience store, supermarket, and you see CBD to be smoked or eaten through gummies or whatnot. Well, yes, all that's real because the FDA has done nothing really to enforce its position. It was provided under the Farm Bill of 2018 the authority to regulate hemp derivatives, including CBD, but it just has never done so. And at the end of January, it announced that, you know what, we know we're supposed to issue these regulations, but guess what, we're not going to do it. And we're just going to punt it back to Congress to come up with a law to address this. So that's why we're in a constant state of flux. And so some states have regulated on their own, and some states have focused on particular types of CBD derivatives from hemp, such as something called Delta 8 or Delta 10. And those are derivatives that are chemically altered that will get you high. And so the problem, the people who are legitimately in the industry have an issue with it because, any child, literally any child can go into a 7-Eleven and buy Delta 8 without having a medical marijuana card, without any oversight, without any testing. So you really have no idea what you're buying. And so it really presents a real challenge in the space. And so for you as employers, the issue is if somebody ingests hemp or CBD from hemp, what does that mean? Well, I have read that over time it metabolizes and it'll look like regular cannabis in your system if you're drug tested, if you're taking CBD. So I'm not a scientist, that's something I've read. So it presents a potential issue that somebody could legitimately not be smoking marijuana, but still test hot because CBD may test hot. So then going forward on the medical marijuana space, back in 2013, there was a series of memoranda by the federal U.S. Department of Justice, and in particular by an assistant U.S. attorney by the name of James Cole. And basically what Mr. Cole said, and what's called affectionately known as the Cole Memo, was that we as the Department of Justice, we really don't have that much of an interest in the medical marijuana state in this country, so long as whoever these medical marijuana companies are operating within strict confines of a state regulated program. And they had 8 bad events that if any of these were violated, that the Department of Justice would consider pursuing claims, such as if you're distributing it to minors, that you're using it as part of an overall criminal enterprise, you're using it to cover up other illegal drug activity, diversion from one state to another. That means if you are in, for example, Denver for a business meeting and you decide that you want to buy all kinds of pot since it's adult use legal in Denver and you get on a plane and bring it back to Pennsylvania, that's a problem. And so companies can't do that either. Any company in the space has to keep it within the state that they're licensed in. You can't take it over state lines. And then if there's public health issues, violence, cultivation on public lands, sorry about that, and possession or use on federal property. So all those things, if you're one of these medical cannabis companies, that'll get you in trouble. And that's what the Department of Justice would pursue. But if you're otherwise fully compliant with state law, they're not going to bother you. And I'm not aware of any of our clients who've had any issues with the Department of Justice for being a medical marijuana program. And quite frankly, these carve-outs have applied equally to adult use programs as well. The next thing is the other thing that's important on the federal government level. Ever since 2014, there's been a rider to the federal budget. It was called the Rohrabacher-Farr Amendment. Now it's Rohrabacher-Blumenauer Amendment. And basically what that says is that you, Department of Justice, we, Congress, are not going to give you any money to go after medical marijuana companies that are compliant with state law. And so this restriction on funding did come up in a series of criminal cases that were decided by a federal appellate court out in California, and the result of which was that the federal appellate court threw out a bunch of convictions on the premise that the Department of Justice should have never used congressional designated funds to prosecute these people and these businesses if they were otherwise compliant with state law. And the appellate court sent that case back down to the lower level court to determine whether or not these people were compliant with state law. And if they were, then it was effectively illegal for the Department of Justice to pursue those claims. So let's fast forward a little bit. We go through, that came out in 2013, 2014, you have Rohr, Barker, Blumenauer. 2018, when Jeff Sessions took over as the Attorney General, he issued his own memorandum. And Jeff Sessions has historically been anti-cannabis as well. And in his memo, he rescinded the Cole memo. And what he said was, look, guys, we don't need the Cole memo because the Department of Justice has and always will have prosecutorial discretion on who it wishes to prosecute. And so he left it up to the individual U.S. attorneys in each state, the federal U.S. attorney in each state, to decide whether or not he or she, on a case-by-case basis, is going to pursue these marijuana operators. And I'm not aware of any one of them have, notwithstanding the Cole memo being rescinded, to have pursued anyone on the basis that the Cole memo doesn't exist anymore. And quite frankly, the federal government, even though it has not reinstated the Cole memo, is effectively taking the same position that it's still out there. These companies are not being prosecuted. But there was, I will tell you, at the time, I remember distinctly in January 2008 when this happened, and clients, thought the sky was falling because Jeff Sessions tore up the Cole memo. And it's had really, I don't think, any effect. And if anything, it's probably actually pushed the impetus to have some form of federal reform sooner than later. So it really hasn't changed much of anything in the landscape. All right. So what are you dealing with when you're dealing with medical marijuana in particular? So again, you have to remember there's two different sets of laws that you may be dealing with depending upon who you are and what your business does. So on the federal side, again, you have the Controlled Substances Act that's always out there. You also have the Americans with Disabilities Act. People claim they're disabled and are entitled to protections under the Americans with Disabilities Act because they have one of the conditions pursuant to which they can get medical marijuana. We'll talk a bit about that later. You have something called the Federal Drug-Free Workplace Act, which applies to certain businesses that are either contracted with the federal government or do business with the federal government. There are certain obligations that are imposed under the Federal Drug-Free Workplace Act, which is really it's somewhat dependent upon the nature of the industry you're in. I once did a presentation on the Nuclear Regulatory Authority and their oversight because of the Drug-Free Workplace Act requirements there. So we'll touch on that a little bit later. And then the Department of Transportation, covers trucking, and so that's a federal law that certainly has implications in the context of medical marijuana. And then on the flip side, you turn to the states. So you have state medical marijuana statutes where there are, last count, I think there's 39 around the 39 states that have a full medical marijuana program at least. A number of the other states have what I would characterize as medical marijuana light. Those are states like Virginia, for example, has a law that only allows you to have a very low THC, in your cannabis products. So it really won't get you high as compared to some of the stuff you can buy now, which will really whack you out. And so it's much stronger than the cannabis than people probably remember when they were in college. And then you have state anti-discrimination and disability statutes. We'll touch upon that in particular here in Pennsylvania. And then you have workers' compensation and unemployment compensation benefits laws. And some states, there are cases out there requiring employers to cover medical marijuana. So we'll try to touch on some of that and hit on some of the cases that have come out over the last couple of years that address those issues. Hold on. There we go. Okay, so let's talk about Pennsylvania. All right. And so what do you need to get a medical marijuana card in Pennsylvania? First, you have to go to a doctor, and the statute contemplates that you're going to your treating physician, and he or she has to be certified through the Pennsylvania Department of Health to give certifications for medical marijuana. A doctor cannot give a prescription for medical marijuana because a prescription is subject to Drug Enforcement Agency oversight. And since medical marijuana violates federal law, they can't give a prescription. So it is called a certification. And the doctor can only give a certification for one of 23 serious medical conditions that are defined in the regulations. There is a piece of legislation that may be proposed shortly here in Pennsylvania that will do away with all those medical conditions and just leave it up to the doctor for he or she to make a recommendation. If you're interested in finding a doctor, the Department of Health has on its webpage. You can find doctors listed there who have gone through the training program in the Department of Health. And I will tell you, it's fascinating to look at the list because there are doctors on that list that include people like dentists or OB-GYN. So, you're hard pressed when you look at the list of medical conditions, hard pressed to see how either one of those types of physicians or podiatrists, how they could be issuing these certifications. But that's a discussion for another day. So the patient's supposed to be under continuing care of the doctor, and the patient's supposed to be able to get basically therapeutic or palliative care from using medical marijuana. And then the doctor can impose limitations through the certification process, and it's otherwise monitored through the program before this certification is issued. Sorry about that, technical issues. So, all right, what are the conditions? So, if you look at the conditions, and this isn't all of them, there's 23 altogether. I mean, there's some pretty serious stuff on there that really the medical marijuana is really seen for some people who suffer from these issues as kind of the treatment of last resort. And that's really conceptually how this program was contemplated. For example, cancer and AIDS and ALS or Parkinson's disease. I mean, these, this is PTSD, Crohn's disease, Huntington's disease. I mean, they're really serious, bad stuff. But it was interesting. The list used to be 17. And when COVID hit back in 2020, they revisited the list and they added things such as anxiety. Now, there's some other ones, but I specifically included anxiety for the purpose of the presentation because I would submit to you, I don't know anyone that doesn't suffer from anxiety. And so, it was funny because, when the liquor stores closed in 2020, and they deemed to be medical marijuana dispensaries to be medically necessary. So we had clients that were making money in COVID that they were never really making money before because the liquor stores were closed. And so everyone was getting treated for anxiety. So, people would argue that Pennsylvania is really a medical marijuana state in name only because you have anxiety now. And really, it's up to the physicians to be the gatekeeper. But, I certainly see that argument in that issue. So let's move forward. Okay. So how does it apply to a patient? So a patient has to apply to get a certification. There's a $50 annual fee to the Commonwealth of Pennsylvania. They get an ID card that's good for 1 year. You can only get into a medical marijuana dispensary if you have an ID card in your ID. And it's limited to getting up to a 90-day supply of marijuana. It used to be limited to 30 days. But, I will tell you, people are getting an ounce of pot, if that was supposed to last for 30 days, I mean, that's quite a bit of pot, and you'd have to really be ingesting quite a bit to burn through your monthly supply. So, but just as a quick aside, when the law passed in 2016, one of my partners, and I used to have it in this presentation, but I'll just share it with you. One of my partners sent me a medical marijuana ID card that an employee had sent to one of our clients. And she had tested hot for marijuana on her drug test. And she was up for being terminated because it violated company policy. And she approached her employer and said, well, look, I have a medical marijuana card. And so he asked me to take a look at it. And I said to him, I said, well, did you really take a serious look at this card? And he said, well, why? I said, well, first of all, the card says it was good until, I think it was October of 2016. I said, The law was just passed in April of 2016, and it didn't go live until 2017. So, the card's bogus on that front. I said also, the card says it's a state of Pennsylvania medical marijuana ID card. I said, there's a problem with that. I said, many of you may or may not know, Pennsylvania is not a state. It's a commonwealth. And if you look at every official document that you've ever gotten, including your driver's license, if you pull it out right now, you'll see that it says Commonwealth of Pennsylvania on it. It doesn't say state of Pennsylvania. And then the best part was, I said, did you really pay attention to this woman's photograph? I said, because if you look at the photograph, it has, she's wearing a t-shirt, a sweatshirt. And on the sweatshirt, it had writing, but the writing was backwards. So that means that she took a photograph of herself in her mirror and made the card. And so our client fired her and never heard from her again. All right, so let's talk about what the statute provides with respect to employers. And here's really the struggle that folks, employers such as yourselves have. And that is the following, that you cannot make an employment decision, hiring, firing, terms and conditions of employment solely, quote, solely on the basis of the employee's status of being certified to use medical marijuana. So what the hell does that mean? Well, I think that the easiest thing to say is if somebody were to come to you and say, hey, look, I have a medical marijuana card, here it is. And you say, all right, well, I'm firing you. Well, that's a pretty clear violation. But then the question becomes, well, what if the person doesn't do that? What if they're just a user, and what are your rights there? So we'll go on further in the statute. So nothing in the law requires you to make an accommodation at your place of employment for somebody to use medical marijuana. And it doesn't limit your ability to discipline an employee who's under the influence of medical marijuana in the workplace or for working under the influence. I mean, the question always becomes, well, how the hell do you know? I mean, you're not going to, typically you will not have the circumstance where you're coming onto a job site at 6 a.m. and you walk in to the job site and there's somebody, sitting under their desk, eating a bag of Doritos and drinking Mountain Dew at 6 a.m. I mean, that may be, a pretty good tell that somebody's doing something. But, somebody could use medical marijuana for PTSD, and they ingest it the night before, stone cold sober in the morning, and you drug test them and they come up that they're under the influence. But are they really under the influence? So it is so imprecise and such a minefield for employers that it's one of those kind of like knee-jerk, ad hoc, facts and circumstances situation that you have to make a value judgment whether somebody appears to be under the influence. It's a dangerous proposition, but that's what you're left with, unfortunately. The other thing, and this gives additional cover for you, the law doesn't require you as an employer to, violate federal law. So again, if you're subject to the Drug-Free Workplace Act, you certainly wouldn't have to make an accommodation to anyone because, using that would certainly run afoul of federal law. And so you don't have to be put in a position that you're violating federal law. So you really, you have outs. And in particular, you in the industry actually have additional outs, which we'll get into shortly. Okay, so what are the prohibitions that an employer, specifically employment-specific prohibitions? So a patient can't operate or be in physical control of anything while under the influence with a blood content of 10 nanograms of THC per milliliter of blood in the blood serum. And I mean, that's the only way you're going to figure that out is to have the accurate drug test performed. But that's a general limitation. And this applies to folks that are working with chemicals, which require a permit from the federal government or state government or an agency of the federal or the state government. So people who are involved with handling or disposing of chemicals, a person who fits this qualification, you don't have to employ that. Also, somebody who's working in high voltage electricity or any other public utility, again, they can't be under the influence of have more than 10 nanograms of active THC in their blood serum. And a patient can't perform any employment in duties of heights or in a confined space. The confined space was really, I think they had mining really in mind because, mining is still not an enormous industry in Pennsylvania, but it's still, not an insignificant industry. which obviously the law went on to specifically provide for mining. But if you think about it, working in duties at height. So if you're having a construction site and you need people to get on ladders or stand on a pallet on a forklift that gets lifted up to the roof to do construction, you can certainly avail yourself of these prohibitions and not be subject to the anti-discrimination provision that we talked about earlier. Which is why I think this is gives employers some discretion, but understanding there's still a risk that somebody would pursue a claim. The next thing, the other restrictions, that a patient can be prohibited by an employer from performing any task that the employer deems life-threatening. Again, on a construction site, clearly there's job tests, even a relatively small construction site. I mean, I would hazard to say that just about anything in the construction field potentially puts people's lives at risk just because of the nature of the business and heavy equipment, heights. And so then the other prohibition is that a patient can be prohibited by working for an employer if performing their work would put the public health or safety at risk. I mean, that in that context is, you think of more like people who run municipal trash removal services or leaf removal services, or things of public water. People in those public health or safety jobs. You don't have to make any sort of accommodation if they're a medical marijuana card holder. All right, so how do you deal with this? Because you have this dichotomy between the federal and the state laws. I mean, look, one of the major issues is drug testing and zero tolerance. There's nothing in the statute that prevents you from drug testing or having a zero tolerance policy, so long as you're not making those decisions solely on the basis that somebody's in a medical marijuana card holder. And that's tricky. So, what the heck does that mean? And unfortunately, I don't really have a very good answer, because it's one of those facts and circumstances situation that you just have to, come as you go, if you will. Hiring and firing decisions, we've covered the ones that you actually can make those decisions without violating anti-discrimination provision. And then again, workers' compensation and unemployment insurance issues. Are these people entitled to workers' compensation if they get hurt and one of the only forms of treatment that works for their pain is medical marijuana? Or if they're unemployed, and they're because of medical marijuana, can they get unemployment insurance? And then we talked about the federal government issues, if you're a federal government contractor. All right, so can an employer terminate somebody for solely being off the clock? And so there's a lot of cases out there. Interestingly enough, there's still cases that are just kind of bubbling through in Pennsylvania. But I will tell you, recently the Pennsylvania appellate court, called the Superior Court, issued a decision which says that there is a private right of action under the Medical Marijuana Act to pursue a claim for violating the anti-discrimination provision. So that is significant for you as employers, because if you violate it, somebody can actually sue you, where in the past it was an open issue. So this case that was in Connecticut involved somebody who was involved in using medical marijuana off-site and after hours, and the employer try to say, well, wait a minute, we had to comply with the Drug-Free Workplace Act, and so therefore it was okay for us to discharge this person. And in that case, the court said no, you couldn't. That the Drug-Free Workplace Act defense was rejected, and that that the fact that the patient was using medical marijuana off the clock still entitled that person for protection from being terminated. So what do we hear in New Jersey? Because New Jersey actually has had a number of cases in this space. And in one case, the first case, the Cotto case, there the federal court said that New Jersey's Medical Marijuana Act, now we have adult use, but just focusing on medical marijuana. And the New Jersey anti-discrimination law do not require an employer to waive drug testing requirements for medical marijuana users. So, but unlike Pennsylvania, New Jersey doesn't have an anti-discrimination statute. So this basically gave employers, much more leeway in New Jersey to deal with people who are taking medical marijuana. The flip side is there was another case where the municipal employer actually had to cover the patient's medical marijuana uh, for a treatment from a work-related claim. So you'll see as we go through some of these cases, they're really all over the place. And so it's the only certainty that I can say to you is uncertainty. And that's an unfortunate reality. Delaware dealt with a similar case. Here was an injured employee was a medical marijuana user, was required to take a drug test, failed, and was terminated. And the court there said that the employee could proceed on his claim that the employer violated their Medical Marijuana Act for his termination. But there, the statute in Delaware, for my analysis, is probably even stronger than that in Pennsylvania, which may account for the reason why the Delaware court, found in that way. And the reason why I'm going through these cases is, when these cases actually work their way through the Pennsylvania court system, and Pennsylvania courts will look to other courts to see how they've dealt with these issues and why I think these are instructive, for the purposes of our discussion. So that gets us to the big issue about drug testing and zero tolerance. And the question is, is there a statute? Whether there's governing drug testing in general. And then even if there are drug testing laws, you have to make sure you're not violating employee privacy issues. And so, what do you as employers need to do? I think the important thing, any employer, particularly people whose businesses are in the safety industry, construction, for example, is you got to take a look at your current written policy that you give your employees on drug testing and on particular marijuana and or any other drugs. For example, you may have a zero tolerance policy on using opioids during normal business hours. And so, then you have to make sure that there's no local law that runs afoul of it. And you have to make sure you stay up to date on the laws because you may need to adjust it accordingly. And so the other thing that's very important, whatever policy you have to make sure it's applied equally to everyone, because otherwise you don't want to create a situation where you're going to create a situation where you're going to have a claim of discrimination because you're treating one person differently than another. I once had a situation where, there is synthetic THC, a product called I think it's Dronabinol, that helps people who are cancer patients for their appetite because of chemo. And one of the talks I gave once before, they were talking about an individual who tested positive for THC and tried to claim that they had this Dronabinol prescription and therefore that's why they were testing positive. And there's an issue because the synthetic, and I don't know the science particularly, but there's an issue because the testing for something like Dronabinol is different than regular THC. And so I don't know if that employee really, got relief, so to speak. Okay, focusing back on hiring and firing decisions. Again, we talked about that you can't make that decision solely on the basis that somebody's certified to be in the medical marijuana program. And that, I was mentioning there's that private right of action that the Superior Court said exists. And that was almost a couple of years ago now. And so the question ultimately becomes, is your job a safety sensitive job that gives you greater flexibility in your ability to deal with people who are medical marijuana users? And so that's, again, it's a facts and circumstances issue, whether or not, your job that you're hiring people for is a safety sensitive job that gets you basically around the issue of the anti-discrimination provision. The other thing, about reasonable accommodations, does the ADA come into play? There are cases, because ADA requires a reasonable accommodation. And I believe there's a case that I'll be hitting shortly, that some courts take the position that an employee cannot claim the benefit of protection under the ADA for a reasonable accommodation at their work site because the ADA is a federal law. And if you're violating federal law, which you would be by being a medical marijuana card user, then you don't get the protections of the ADA. And again, just to reemphasize, a patient can't be prohibited by you as an employer from performing any task where you deem it to be life-threatening or which could result in public health or safety risk. Again, you think about an electrician on a construction site. You can certainly see how that would create a safety risk or a public health risk, because what if they have a real, electrical fire. So those are, again, job description. What's the job description? When you're putting together your job descriptions, if you're doing that and you want to rely upon the safety exemptions, you should be very specific, that the job entails public health or safety risks, it gives you better cover from a policy standpoint when dealing with employees, that there's no mystery, that they knew up front that their job was safety sensitive and not otherwise subject to protection. And so it's very important that you have to have this, what I call an interactive process between you, your HR folks, and your employees, to at least do your best to get it right. Okay. So, and again, like I said, although ADA may not apply, depending upon what state you're in, there could be state anti-discrimination statutes, or like in Pennsylvania, the medical marijuana law, that could require an accommodation. So again, it's a very, very state-specific analysis that you have to be sensitive to. So the last time I did the analysis, here's a map. And so those that are in red were states that specifically do not require a reasonable accommodation, and the ones in green require it. The rest that are in gray, either at the time I put together this analysis, didn't have either. But I'm sure the map has changed, but it's really only for illustrative purposes only, to see, it's really inconsistent depending upon where you go around the country. But I will tell you, this is here to stay. When you consider some of the more recent states that have adopted medical marijuana programs, such as Alabama and Utah, to name two, not exactly states that have a history of being very progressive on social issues. And so it only is indicative to me that, medical marijuana is not going away when you have these extremely conservative states, adopting these programs. So again, just for illustrative purposes. Okay, so can you terminate somebody for being off the clock marijuana use? Again, it just depends where you are, and looking at what these other states have done, again, is instructive. So Colorado says that you can, and other states, say that you can't. Massachusetts, Rhode Island, and Connecticut, for example. So then, what about workers' compensation issues? See, at least in Pennsylvania, in cases where the injury or death is caused by intoxication, there's no workers' compensation entitled. But that's it's you as the employer, you have the burden of proof on that. So, if somebody is high on the job and gets hurt, you have a defense to the workers' compensation claim. And then there's the issue of whether or not you're obligated to reimburse costs for the certified medical marijuana that the patient gets. Next, is an employee, if the employee is terminated for off-site marijuana use, are they entitled to unemployment compensation benefits? So again, New Jersey federal court held that its Medical Marijuana Act and anti-discrimination law did not require an employee to waive drug testing requirements for medical marijuana users. Again, so that's against the employees. And similarly with the medical, but then the flip side, as I noted earlier, the Fearhole Township was required to at least cover the medical marijuana treatment for a worker's work-related injury for treatment. Again, going back to what Colorado said, there the employee was required to take a drug test that failed. And again, the court said that there is an anti-discrimination claim under their statute. So it's such a hodgepodge, it makes it very difficult for you as employers to deal with these situations. And again, I talked about the federal contractors, who is covered, those who are, have contracts with the federal government or work for the federal government. And what are the penalties for noncompliance? Typically, it's not that you lose your contract, but it requires an analysis of the particular law that applies to you and the federal contractor that you're working with. So, for example, I used the Nuclear Regulatory Authority before, which is an industry that I have some knowledge about, but it just depends. And it really, the problem is, it almost puts you in a Hobson's choice of how do you comply with both state medical marijuana laws and federal marijuana laws. I would submit it's pretty difficult to comply with both. Drug-Free Workplace Act. So this was, just very briefly, came out through the Ronald Reagan's administration, and a concern that the use of drugs by federal employees presented health and safety threats to the public and other federal employees. And so the act requires some federal contractors and all federal grantees to agree that they'll provide a drug-free workplace as a condition of receiving a contract or a grant from a federal agency. So that's the ultimate risk, that you can lose that grant or contract. And so, and this is just an anecdotal analysis that I put together from the nuclear industry. And so here, a licensee at a power reactor has to participate in drug and alcohol testing under the fitness of duties rules. And typically, under the Drug-Free Workplace Act, that's what they look at are these fitness for duty rules. And here's just an overview of how that works in that context. And again, it's illustrative of the fact that there's a whole nother area of law that may run afoul of a state medical marijuana program if you're subject to the federal drug-free workplace laws. So what are the takeaways? Let me talk about that one Colorado case, because actually I had removed it from the presentation. So in that case, it was a Vietnam veteran who worked for DirecTV, and he was wheelchair bound, and from all outward appearances, was the dream employee for DirecTV. But he used medical marijuana after hours off-site to help treat, among other things, his PTSD. He was drug tested. His drug test came up hot. He was terminated. He sued. And you think Colorado, because Colorado was one of the original states to have a medical and an adult use program, would have been much more lenient. And in fact, it was the complete opposite. And in that court, when this former employee tried to say, well, wait a minute, I'm disabled on the Americans with Disabilities Law. And the court said, so sad, too bad, because you can't claim protection under a federal law when you're violating a federal law by taking medical marijuana. And so that's just another example of how courts are really just all over the place. So for you as employers, and I'm happy to take questions in our remaining time, the reality is legal cannabis isn't going anywhere. In all likelihood, this time next year, if I do the same presentation, we're probably talking about an adult use law here in Pennsylvania as well. Governor Shapiro, in his proposed budget bill, has a placeholder for adult use cannabis to be taken into account in the budget, which is a very significant step towards pushing forward for an adult use law. Last summer, a bipartisan bill was presented in the Pennsylvania Senate for an adult use statute. And that's not the first time that's happened, but it was significant this time. And the reason why it was significant this time is that it is the very first time that any one of these bills ever got into a committee for discussion and debate, and which is a necessary step before a bill can then be passed and then signed by the governor to go into law. And so there are bills that are out there that we will probably be seeing sometime in the next few months that may or may not get passed that will allow some form of adult use. I mentioned earlier that there was another medical bill that may be introduced that some people claim will just be another version of adult use marijuana without really calling it that. And that's a revised version of the Medical Marijuana Act, pursuant to which the 23 serious medical conditions that are now defined by statute and regulation will be repealed. And it'll just be up to a doctor and his or her patient to make the decision whether or not that person should be certified to use medical marijuana. So you think, anxiety would open the door at that point. I mean, you could literally go in, and if your doctor is cooperative, you go in and have a hangnail and say, I have a hangnail here. Okay, I'll give you medical marijuana. So, I mean, that's an issue that we're just keeping an eye on. So the keys are, you have to accept the fact it's not going anywhere. You have to know what laws apply to you, whether you're in Pennsylvania or have businesses in other states. Because if you have activities in multiple different states, I would submit to you, you're going to have to revisit your employee handbooks and have different handbooks in each state dealing with these particular issues, because the laws vary from state to state. So that's, and where necessary, make sure you comply with federal law. Make sure you're revisiting your employee handbooks as these laws continue to change, because you don't want to get caught with your shorts down, so to speak, that your handbook doesn't cover the laws that are in place. And like I said, take a critical look at your job descriptions. And if your job descriptions aren't fulsome enough to address safety sensitive things, then I think you really need to take a step back and take a review of those and work out those job descriptions and make sure your handbooks are up to date and consistent with the law that applies. So, I wish I had a rosier picture to give you. You're in a tough environment with these laws out there, but if you exercise, what's that? An ounce of prevention is worth a pound of cure. I mean, that's really, if you do as much as you can on the front end to make sure you have adequate policies and procedures, adequate job descriptions, it's really a risk mitigation issue of putting yourself in the best possible position to address an anti-discrimination claim if somebody were to say, well, you fired me because I told you I'm a medical marijuana card holder. Happy to, I have about 10 minutes. Happy to take any questions if anybody has any questions. And look, feel free, reach out to me after this if you have any follow-up, and I'm happy to share my PowerPoint with you if you'd like as well. John?
Yeah, any questions out there? I don't see any in the chat. So either people waiting to ask or you answered everything.
I have a question. If someone came on a site smelling of alcohol, that same can happen with marijuana. If someone smells like alcohol, you assume that they might be drunk. If they smell like marijuana, you can probably assume that they're high.
Mm-hmm.
Now you say, if they have a medical marijuana card, you can't fire them, but could you kick them off the site?
Yeah, absolutely. You can
for that day, and they lose out on a job that day.
You can, Seth, you can fire them because if you have a policy that says you can't use drugs or alcohol or be under the influence of drugs or alcohol on the work site, you absolutely have the right to fire them, as long as you can justify that they were under the influence, and that's the dicey thing. Yeah, I think if somebody comes onto the property and stinks like pot, has bloodshot eyes, and is carrying a pepperoni and anchovy pizza at 7 a.m. I mean, I'm a hard ass, but no, I mean, it's one of those things. It's an imperfect science, but if somebody smells like pot, I don't see that there's a reason why you can't say you can't work here today, and come back another day when you're sober.
Yeah, because I mean, instead of losing a person, maybe just kicking them off the site, and then if they do that too many times, then they can't pay their bills, so they're gonna have to either stop or find another way to smoke it.
Yeah, no, it's certainly an issue, but you have leeway is my point.
Okay.
It's not these many things in the law, Seth, are not hard and fast. And this is certainly one of them. And unfortunately, a lot of it is your discretion. But if somebody stinks like pot, just like somebody stinks like alcohol, it's the same, in my view.
Thanks.
Yep.
Anyone else? Going once, going twice. Hearing nothing, just on behalf of the KCA, we'd like to thank you for kicking off this series and looking forward to working with you this year and talking about this subject some more. Yep. It's not going away, like you said.
It is not going away. Feel free to reach out, and best of luck to everyone. It's a challenge, without question.
Definitely.
Okay.
Thank you.
Everyone. Be well. Yeah.
Thank you.
Bye-bye.
Thank you.